Remington recently bent the knee at the will of the gun controllers in regards to their lawsuit regarding the Sandy Hook shooting. Now, this is a situation that might be shocking to you because we have things, and we've talked about this in the past, like the PLCAA, which is supposed to protect firearms manufacturers from frivolous lawsuits which would potentially bankrupt them. This is a big topic, and I think that a lot of people have been talking about this, but this specifically, I found an excellent article from Open Source Defense that I wanted to kind of highlight and talk about today to talk about some of the information that is going around as far as why they did this, because there's a whole lot going on here, and I think it's good for us to understand the bigger picture when it comes to this game of cat and mouse with the gun controllers and the gun industry. This is something that's very interesting. If you want to read more about the article directly down below, you can, but I'm just going to be showing you a few things here. Now, this first article is the one that actually made me aware of this initially. This was gun makers offer Sandy Hook families $33 million. Here's what they may be considering. This is the one that I initially found out about Remington actually agreeing to settle and pay out the victims' families. And this is pretty interesting because, again, this is a situation where they're suing the manufacturer of the firearm for negligence in how they marketed it, which is very interesting to me because someone going out and committing a violent crime with it doesn't seem to me the way that Remington marketed it. Correct me if I'm wrong, but I don't believe Remington ever made a advertisement on social media or on TV or newspaper articles saying Remington or Bushmaster AR-15s, the choice of school shooters everywhere. I don't believe that that was ever said, but Remington is actually going to be settling after recently a judge actually declared that the case could move forward, because this has been going on since 2014, but it was only recently that a judge actually ruled that this could continue forward and the lawsuit could go again and actually be put in place, because there's tons of lawsuits all over all the time being filed. Most of them don't actually ever make it to trial, but this one is being allowed to proceed to trial. Now, I wanted to link here Open Source Defense number 128, Nobody Needs an Assault Lawyer. I think this is a really good title and a very clever way of talking about this, because when we talk about this game of cat and mouse when it comes to how lawyers do things, I am very fascinated with how FPC and various other legal teams go about actually fighting for our gun rights, but this shows a good insight into how the anti-gun side can be just as good, if not better, at this game. So I'm going to read to you a few parts of this article. I'm going to kind of skip around, but if you want to read the whole thing, I will have this link from Open Source Defense linked down below. Almost 7 years ago, families of 9 Sandy Hook massacre victims sued Remington. This past Wednesday, Remington offered $33 million to settle the case. There are 3 parts to the story to dive into: how the lawsuit can happen, why Remington has to settle, and what's next. Now, this first big section here talks about the history of why the PLCAA, the Protection of Lawful Commerce in Arms Act, was actually put into place and how this actually all started. Because apparently back in 2000, you know, on Smith & Wesson revolvers and how some of their firearms, they have those little locks. I think they called them the Clinton lock. I can't remember the exact phrase that's commonly used, but you see those on a lot of Smith & Wesson revolvers. That is part of a wide variety of frivolous lawsuits. This was organized and carefully conducted campaign of dozens of frivolous lawsuits calculated to bankrupt Smith & Wesson through court costs. In 1998, the Handgun Control Inc., which was formerly known as the National Council to Control Handguns and is now known as the Brady Campaign, had a brilliant and audacious move and nearly brought HCI to the victories it had long been denied in the legislatures. So gun control wasn't working, so they decided to try to bankrupt Smith & Wesson through various frivolous lawsuits. Now, it goes on to talk about how they just kept filing more and more and more. So the lawyer that they actually talk about assembled several dozen big city mayors to file innovative lawsuits against handgun manufacturers. As then mayor of Philadelphia, Ed Rendell, explained, the suits were carefully structured to maximize litigation disadvantages for the manufacturers. The various suits were structured to prevent their consolidation, which could reduce litigation costs. Notably, the plaintiffs targeted only handgun manufacturers, not long gun or ammunition manufacturers, some of which have considerably deeper pockets for litigation expenses. Which is interesting to talk about because it's all tactics for them. They wanted to get their desired outcome, but they went after it in the way that was going to be the most effective, which is just, it's very interesting to see the clever ways that these terrible people will go to restrict your rights to keep and bear arms. The particular claims in the suits vary tremendously. Product liability was used where still available, but other claims involve some novel theories of negligence or of ultra-hazardous activity. No precedent had to be allowed for such suits against manufacturers or retailers of dynamite. The ultra-hazardous activity was using dynamite, not making or selling it. The HCI lawsuits took the theory further and said that mere manufacture and lawful sales of handguns could be ultra-hazardous. So they're saying that because the firearms are made and brought into existence, that is ultra-hazardous, which is really the mindset that many of these gun controllers still have. Now, none of the mayoral lawsuits resulted in a verdict for the plaintiffs, and many were dismissed at early stages. Nevertheless, the multiple lawsuits were quite costly to defend. President Bill Clinton's Housing and Urban Development Secretary, Andrew Cuomo, arranged for dozens of local housing authorities to bring their own suits. In 2000, Smith & Wesson capitulated under pressure from its then owner, a British conglomerate. The lasting symbol that capitulation is the Smith & Wesson internal lock on their revolvers. So this is actually super interesting. It then goes on to talk about the requirements that were put in place by Smith & Wesson retailers and distributors if they wanted to actually be able to sell their firearms. So limiting how they could sell them, what they could do, how they would have to actually carry insurance and whatnot. And there were also provisions for retroactively tightening the noose further, meaning that if they wanted to change the deals, I've altered the deal, I've altered the deal, pray I don't alter it any further, or something like that, right? So then fast forward to 2005 when actually the PLCAA goes into effect, and it was because of this. So people act like, the Protection Lawful Commerce in Arms is just some sort of like, it was the gun industry just wanting to throw their dick on the table and establish dominance and make it so that gun makers could willingly kill all kinds of minorities and underprivileged youth. When in reality, gun controllers were throwing so many frivolous lawsuits at the table that it was becoming too costly for manufacturers to actually fight it. And now this article then goes on to talk about why Remington has to settle, and this is really the interesting thing. Offered to settle is a bit of a misnomer. Remington has exactly two options. They either settle the case, or they cease to exist as a company. The reason that they say that is because Remington has been in bankruptcy for so long, they can't afford to lose, but they also can't afford to win. And I think that's an excellent way to put it, because if they were to lose this, it would financially destroy their company, right? More than the initial settlement amount of money. But if they were to win, it would be so difficult for them to actually go through and defend against it that it would be cost prohibitive, and they're already in bankruptcy, so they don't really have a whole lot of money. People love to talk about how gun companies are so big and so massive, but this comparison right here puts it perfectly. Ruger is the biggest publicly traded gun company in the world, and their market cap is $1.3 billion. For comparison, Google made $18.5 billion in profit last quarter, meaning Google's weekly profit exceeds the entire value of Ruger. We're not that big of a deal. I mean, we're a pretty big deal, but we're not that big of a deal in terms of pure monetary value. And this is where I really wanted to talk about that. So in these lawsuits, it's 10 to 100 times cheaper to be a plaintiff than a defendant. Since running up costs is the goal, the rational strategy for the plaintiffs is to never not be filing lawsuits. So they're going to say, hey, look, we just have to keep throwing darts at the wall, and I have an unlimited amount of darts. I can just keep throwing darts all day, and if I land one in that 10 ring, boom, money raining down upon us, and they win. And that's really where this gets so interesting, because this is the strategy we're going to see going forward. This article continues to go on and talk about things like how several states like New York and California have several laws regarding nuisance items, and how there's strategies being played by especially New York to allow a little crack in the PLCAA. And while maybe that crack isn't really there and it's just visual and it looks like a scratch that you'd see on your gun, it doesn't matter if the crack is actually there and there's enough room to fit a lawsuit in. What matters is how costly will it be for the actual gun company to defend it. And this is really where it's going to be going forward. And this is my trouble that I have with Remington in this situation. Is it's unfortunate that they were willing to settle, because them being willing to settle shows that there is a chink in the armor. There's a weakness. There's a weak point that these lawsuits can continue forward in. And that's really where I get nervous about this whole situation, because this proves that it is a potentially viable strategy to the gun controllers to go after and try to destroy the firearms industry without actually having to pass any regulations. And that's really, I think, the biggest deal here. This was a very interesting read, and I enjoyed every second of reading it. I really just wanted to bring this forward to you because when we talk about Remington, I think there's a whole lot more at play than just Remington kind of sucked as a company. They ran their business into the ground. They happened to buy Bushmaster, who then had a little bit of troubles with the whole marketing and whatnot, and this lawsuit. Now Bushmaster's back up and running under a different name. Now Remington is settling. This is bigger than just Remington in that specific instance. And yes, Remington has failed to produce firearms that people really want and produce them at a quality that people really truly think of when they think of the Remington name. But I think this is a huge deal as far as how this could have a big impact on the firearms industry as a whole. I really am curious to hear what you guys think down below. This is more of a thought-provoking piece, or at least I tried to bring it forward in that way, and I think that Open Source Defense did an excellent job of bringing that thought out in my brain. Whether my thoughts are very deep and intrinsic and all that valuable, probably not. But I hope that this inspired some sort of thought for you guys and was entertaining in some way to learn more. Because ultimately, I think this is a big deal, and not that many people are really talking about it and the bigger implications of it. Let me know what you think down below. You guys know the drill. Have fun, be safe, stay dangerous. Peace.